All rise.
Welcome to the Irish Courts podcast. This is our first series where we explore seminal cases and key moments in the evolution of the Irish court system. In this episode, we explore the Julia Clarke case, a young woman who was sentenced to prison for a kiss.
If you must kiss, you ought to be careful. That at least is the experience of Julia Clarke, who has been sentenced to a month's imprisonment for the Irish Free State.
But her young boyfriend walked free. October 1937, the Intelligentsia Journal in Pennsylvania.
Dundalk, Irish Free State. Julia Clarke, a Scottish lass, blue-eyed and brunette, was barred for life from the Irish Free State for kissing her boyfriend in public.
So the young couple were prosecuted under Section 18 of the Criminal Law Amendment Act 1935. That was a piece of legislation that had been passed a year before, and it did a lot of things, but specifically for the purpose of this case, it made it an offence to publicly commit any act that would offend modesty, cause scandal, or injure the morals of the community.
Dr. Niamh Howlin, Associate Professor at University College Dublin, Sutherland School of Law.
It's something from a different world. To set the scene, on a lovely summer's evening in Blackrock, County Louth, a seaside town, a young couple were spotted lying on the grass in a romantic embrace in the grounds of the churchyard. And a local man, a man named Thomas Murphy, sees the young couple and he rushes off to tell the parish priest and the Gardaí. Members of the local vigilance committee came to see what was happening, and they kept their eye on the couple while they were waiting for the guards to arrive. And when the guards arrived, they questioned the couple, and the couple insisted that all they'd been doing was kissing. So the young man in the case had the charges against him dismissed. The only implication for him was that he had to pay the costs, and he had to pay a fine that went to the St. Vincent de Paul charity. The young woman in the case was sentenced differently. The legislation did allow for fairly high sentences and fines to be imposed. The district justice, and this was Justice Goff, said that the case wasn't all that serious. So he imposed a 1-month custodial sentence on the young woman. Now, luckily for her, she'd already left the country. She was back at home in Glasgow at this stage, and there was no expectation that she would ever serve that sentence. District Justice specifically said that the Gardaí should not try and enforce the warrant, that it was really just a deterrent to stop her coming back into the locality. Her name was reported in the press. She was convicted and sentenced, whereas the young man, his name wasn't reported and he had the charges against him dismissed. That sense of the woman being responsible definitely comes out in the reports from the court proceedings. Well, it was said in the case that the young man had been very much influenced by this woman and her get-up. Was the word that was used. And it was very much implied that he had been led astray by her. And I think the fact that she had come over from the United Kingdom was also something that went against her. The Julia Clarke case in 1937 was really just one of several controversies with which Mr. Justice Bartholomew Goff was involved as a judge. And complaints were made about him on a fairly regular basis throughout his tenure on the bench. And I've come across a memo from the Department of Justice, which I can quote from. It said, "Complaints about justices are comparatively rare and mainly relate to 2 or 3 individuals who indulge in too much unnecessary and controversial comment from the bench. By far, the worst offender in this respect is District Justice Goff, who considers it his duty to press publicly for such amendments of the law as seem to him desirable."
Judge Goff was one of 27 men appointed as the first District Court Justices under the District Justice Temporary Provision Act 1923. He had previously served as a temporary circuit court judge during the Dole court period and was an advisor along with James Creed Meredith and George Nicholas to the Committee on the Winding Up of the Dole Courts. Goff had been appointed as a solicitor in 1916 and had been an early member of Sinn Féin and the Gaelic League, and was author of and contributed to several texts on the Irish language. Records from the Law Society indicated that in 1920 he had written to the Council of the Law Society to ask for their intervention. because of efforts by the British military authorities to disrupt his practice as a solicitor. Judge Goff served as a district justice for Louth, Meath and Monaghan and died in October 1957, aged 78.
There was never really a question over his ability as a judge, and there weren't any complaints about his sentencing or his convicting or anything like that. But he did make a lot of pronouncements about things that had nothing to do with the cases that were coming before him. You know, one of the things that district justices were in charge of was granting licences for dance halls. Justice Goff often made it quite difficult to get a licence to hold a dance, and he was quite negative about the evils of modern dancing. In one case, in the 1940s, he said the whole country has gone mad on dancing, and he didn't want to give a late licence for a dance if it wasn't organised by a parochial committee, or if it didn't have some members of clergy present, or if it was some kind of an Irish ceilidh dance, that was better, but not the modern and foreign types of dances, which were going to lead to sexual impropriety. A lot of the statements he made were his personal views about dancing and drinking and gambling. So he had quite conservative views on all of those things, which again, we can see playing out in the Julia Clarke case. So this case was fairly widely reported in Ireland. It did make it into some of the national papers, so definitely the Irish Press and the Irish Times reported on it, as well as the usual local newspapers. And then it was picked up by foreign press, and it was reported in the United States, in Canada, in the UK. There's footage of her appearing on Pathé News with a voiceover explaining what had happened in the case.
If you must kiss, you ought to be careful. That at least is the experience of Julia Clarke, who has been sentenced to a month's imprisonment for the Irish Free State after kissing a boyfriend at Blackrock. But as Julia is far away in Glasgow, she should worry.
And I think there were a few reasons why this particular case, snowballed and gathered so much attention. First of all, I think because Justice Goff was known to be a very outspoken judge, his courtroom was more likely to attract press attention. Secondly, I think the fact that Julia Clarke herself, so the young woman in the case, engaged with the media in the UK, I think that really helped to give legs to the story. And even in the aftermath of the case and the sentencing, that really wasn't the end of it. Justice Goff continued to be featured in news reporting because he tried to exclude certain elements of the press from his courtroom.
The Irish Times reported on Saturday, November the 13th, 1937, that District Judge Goff announced at Drogheda Court that in all cases prosecuted under the Criminal Law Amendment Act, the press and public will be excluded from court. He stated, "The occasion of my making these arrangements was the scandalous treatment that was given by a section of the yellow press, mostly imported, but including one notorious Dublin press, to the recent Blackrock indecency case." It was further reported that he concluded by saying that if this thing happened again, he would ask the Attorney General to put a couple of the offending editors who were within his reach in the dock.
So it sort of trundled on, and it was, the scandal that kept going for a few weeks.
Historian Dr. Mary McAuliffe, lecturer and director of gender studies at University College Dublin.
Well, I mean, when you think about it, a man and a woman go down to a beach, they share a kiss. They're seen by neighbours who happen to be part of a vigilance committee. They're tried under an act that has just been, was 2 years old at that stage, known colloquially as De Valera's Vice Act, an idea that certain acts of immorality needed to be tried as criminal cases. And then when it's brought to court, the man gets off and she's sentenced to a month in jail. Now, she doesn't do any jail time because, of course, she's gone back to Glasgow. But of course it makes international headlines and it makes a laugh of conservative, backward, Catholic, priest-ridden Ireland.
There was a sense of mocking and a sense of ridicule. But at the same time, it served a purpose because it did get the message out there that this kind of thing wouldn't be tolerated in Ireland, down with this sort of thing. It served a purpose for the state in one way, even though it embarrassed the state in another, I think. Particularly at this time when there was a real I suppose, a moral crusade about what was deemed evil literature. So publications and films coming in from abroad, particularly from the UK. There was a sense of trying to seal the borders and stop the filth from getting in, essentially. And whether that came in the form of British tabloid newspapers or books or films or even young women from the UK who came over to seduce young Irish men. Whatever had to be done to maintain the purity of the Irish people or maintain the external image of the purity of the Irish people.
This is a post-colonial state, and I think we always have to remember that. And in a post-colonial state, you're developing a sense of identity that is not the coloniser. And oftentimes that takes a turn towards traditionalism, conservatism, purity, morality, and particularly when it comes to women, respectability. And the idea of the respectable Irish woman becomes dominant. And there is a defined respectability. It's caught up in the woman's body, woman's domesticity, reproduction can only happen within marriage. And the same with homosexuality, that was the English disease. That sort of thing never happened in Ireland before the English came here, or those English women coming over here. And if you look at the work of, for example, Mary Ann Valulis, historian, she talks about the construction of the Irish woman in direct opposition to not being English. Not, having the bob, listening to jazz in the 1920s, wearing too much makeup, the paint pot basically, and the rouge, going to dances, without a male escort, your brother or some male member of your family, misbehaving in that way. That was England, and that was English, and that was the coloniser. That's how they behaved. Irish women did not behave like that. And of course, the fact that Julia, although of Irish descent, was living in Glasgow made her foreign, made her other, made her different. She was bringing back those behaviours into Ireland. So that could be also why she gets such a stringent sentence.
These sorts of cases definitely had a chilling effect on society and on people's freedom to, meet with other people, to develop relationships, to do whatever it is that people want to do. So I definitely think that this case had a chilling effect on personal autonomy for both men and women in the state, I would say.
Oh, absolutely. I mean, even to be read off the altar, not to mind a court case taken like this, had a huge impact on a person's lives. And if we look at the immigration rates in Ireland, a lot of it was for economic reasons, but some of it was people getting out of this stultifying country where, in terms of morality, your behaviour was monitored by priests, by nuns, by the Legion of Mary, by vigilance committees, by all sorts of different sodalities in local areas, by your neighbours. I mean, the Valley of the Squinting Windows was not a lie in many ways.
Well, first of all, I think it's worth pointing out that this wasn't the only case that was prosecuted under that legislation in that year. So even in the very first year after that act was passed, there were 157 prosecutions brought in district courts around the country. Of all the cases that were prosecuted under that piece of legislation in the year, we only really have heard about this one. And you have to go digging to find others. Part of that is to do with the supposedly extreme narrative in the case. All they were doing was kissing, and then she was sentenced to a month's imprisonment. But I think if we dig past the headline a little bit, there is a little bit more to it than that. If we were to look at the types of sentences that are imposed at this time for other kinds of sexual offences, for example, I've seen many examples of cases where men were sentenced to 12 months with hard labour for engaging in homosexual acts, or even up to 7 years imprisonment.
Then the Vice Act, of course, is used against homosexual men. And there has been a successful campaign to get a lot of that exonerated and apology by the state. But it is horrific what happened to those men. It ruined their lives because, of course, their names appeared in the newspapers once it went to court. And that was it. Everybody knew who they were and what they were doing. The fact that they were committing these so-called immoral acts, sinful acts, meant that unless they had a very thick neck, they were going to have to leave or get out or, live a very difficult life.
And it was really symbolic of the moral crusade that the state was on at the time. And not just the state, but also private individuals. We said that the couple were spotted by the local vigilance committee. I mean, these were ordinary members of the public who took it upon themselves to police morality in their communities. They would sometimes hang around in places where people were likely to get up to illicit things. So they might hang around outside dance halls at closing time, for example, to try and catch people in the act or deter them from wandering off up dark alleyways and things. And they would sometimes report to their local parish priest, or sometimes they'd report to the Gardaí, as they did in this case. So it wasn't just the state, it was people themselves were enforcing this new sense of morality. From the late 1920s into the 1930s, there was a real moral panic in the Free State about morality and sexual morality in particular. And a committee that was known as the Carrigan Committee, after the person who chaired it, was established to look into juvenile prostitution and the age of sexual consent, to see what law reforms, if any, were needed there. Now, the committee went a bit further than its brief, and it considered consent, public indecency, prostitution, solicitation, unmarried mothers, dance halls, contraceptives, sexual abuse of children. So a very wide range of different types of sexual activity were considered. And it made a series of different recommendations. The Criminal Law Amendment Act 1935 was passed following the report of that committee and the report of a Dáil committee soon after. And one of the things that the 1935 Act is most famous for is the contraception ban. So it imposed a ban on the importation and the sale of contraceptives. It also raised the age of sexual consent from 16 to 17, and it amended the criminal law in many different ways in relation to public morality and sexual crime, including this new offence under Section 18. The offence under Section 18, so again, it was to publicly commit any act that would offend modesty, cause scandal, or injure the morals of the community. It was similar to a previously existing common law misdemeanour, so a common law offence, which was outraging public decency. But you can see from the way that it's drafted that it goes further than that. So it was a very broadly drafted provision. And the idea was that a lot of discretion would be left to individual judges as to how they'd interpret it and how they'd apply it. And even at the time when it was being passed, the commentary was, this is very broad. And the Irish Law Times in 1936 said a great deal of common sense will be required in the interpretation of this act. So moving on into more recent times, it wasn't until 2013 that this provision was declared to be incompatible with the 1937 Constitution. That was Mr. Justice Hogan in the case of Douglas and the DPP. So essentially what happened in that case was Justice Hogan said, well, what does causing scandal actually mean? Or what do we mean by injuring the morals of the community? A person who's accused of a crime is entitled to know what they're being accused of. And this offence was just too vague and too imprecise to be compatible with the Constitution. So those offences under Section 18 have now been struck out. You know, it was within this same 10-year period that the marriage bar was introduced for the civil service and then later for primary teaching, that women were essentially being kept off juries through legislation.
So you have everything from the juries' bills in 24 and 27 that restricted and ultimately prevented women from participating in juries. So if you say equal citizenship is about, in terms of the law, having a judgment by a jury of your peers, obviously that is not the case until the latter part of the 20th century for women, because women don't participate on juries. Well, I think it fits the pattern of how women were treated in the Irish Free State from the setting up of the Free State in 22. From the very beginning, equal citizenship was contested, even though it's granted in the 1922 Constitution, full and equal citizenship in terms of voting rights. But from the very beginning, you begin to see pieces of legislation that chip away at women's position vis-a-vis work, involvement in society, political representation. In every way, women are beginning to be pushed back into the domestic and becoming second-class citizens within society. And it's not just politically, it's also there's a new moral code. The moral code of the new society is influenced by, obviously, Catholic social thinking, but also a very conservative society that pre-existed the Irish Free State. There may have been moments of radicalism and more liberal ideas, particularly from the first wave feminists, but they were a minority within a conservative majority. But also then the controlling of the workplace, giving up your job on getting married in the civil and public service.
In 1924, the minister was able to make regulations under the Civil Service Regulation Act, which said that a female civil servant who gets married must leave the service. Then in 1926, there was an act which said that some civil service appointments could be limited to men only. And this was generally a way of keeping women in the civil service at the lower grades and men at the higher grades. And then in 1936, then there was an extension of the marriage bar to primary teachers. And in that 10-year period, an awful lot of other public sector bodies and private companies like banks, for example, had started to bring in marriage bars. So not all marriage bars were set out in legislation, but they were definitely very much an accepted part of working life.
And you have the Censorship Acts, which didn't allow women information on their reproductive bodies, initially barred information on contraceptives, and then they get banned entirely.
And the ban on contraception, which was in the 1935 Act.
And again, it takes another 50 years, 60 years for that ban to be overturned. Even into second wave feminism, the banning of magazines from England, or the ripping out of the pages at the back that might have information on clinics in England or information on contraceptives. And this is the 50s, 60s, 70s. So we're talking about a very long time in which women's bodies were controlled.
It's definitely part of a wider move away from the gender equality that was expressed in the 1922 Constitution and then what we end up with in the 1937 Constitution, which is Article 41 and the place of the woman in the home.
Many other things, just picking away at women's position within the public realm and ensuring that the domestic, marital, reproductive, respectable woman is the model on which all women needed to base their life experience and their life choices. When they didn't do that, as we know, they were condemned in all sorts of ways, read off the altar, incarcerated in Magdalen laundries or mother and baby homes. So the whole idea that women were confined to the domestic becomes encoded both in law but also societal expectation and tradition. So what happens in 1937 with Julia Clarke isn't extraordinary. That, stemmed from this idea of the moral, respectable domestic woman. And Julia Clarke was none of those. When you look at the Julia Clarke case and the reporting on it, it's a bit salacious, it's a bit mocking of Ireland. What the judge is saying is her immorality was absolutely on display and therefore that sort of Irish woman shouldn't be in Ireland. I think it's a fascinating case. It's a very small case, but it is absolutely emblematic of treatment of women in this country for a very, very long time.
The Julia Clarke case, a small case that gives us a real insight into the treatment of women in Irish society and in law. You have been listening to an Irish Courts podcast, a Curious broadcast production with the Court Service and the Judiciary. Our thanks to our contributors, Dr. Niamh Howlin, Associate Professor at University College Dublin, Sutherland School of Law, and historian Dr. Mary McAuliffe, Lecturer and Director of Gender Studies at University College Dublin. The audio extract from the British Pathé film Jail for a Kiss is courtesy of the British Pathé Limited.